Fires are devastating events for property owners and tenants alike. An apartment fire can ravage the building, and personal property can be damaged by the water and smoke. Whether you're a landlord who's experienced firsthand the challenges that come with dealing with an apartment fire, or you're a tenant who's been impacted by a fire in or near your apartment, it's never too late to learn about what the next steps should be, especially as it relates to a landlord's responsibilities and the tenant's rights afterward. The most common causes of apartment fires. Apartment fires are scary. The source of apartment fires can be any number of things, but some of the more common causes are 1. Cooking equipment. 2. Electrical equipment. 3. Candles. 4. Portable heaters. 5. Smoking. 6. Faulty wiring. 7. Lightning. Negligence is a situation in which someone acts carelessly without regard to another's health, safety, or well-being. Action or inaction that causes harm can also be classified as negligence. Landlords are responsible for making reasonable efforts to keep their rental property safe for their tenants. Renters are not responsible for the general upkeep of the apartment building or maintenance issues that may plague the building, such as leaky roofs or faulty plumbing. If the landlord's actions or inaction place the health or safety of tenants at risk for harm or cause damage to tenants' personal property, the landlord may bear the full brunt of the responsibility after a fire. What are a landlord's responsibilities after a fire? According to the warranty of habitability right, tenants have a right to a livable apartment. If a fire destroys the apartment building or any part of their apartment unit, it's the landlord's responsibility to ensure the problem is fixed as soon as possible, if not within 30 days. It's important to note, however, that the landlord is not responsible for repairing minor damage caused by an apartment fire. Tenants' rights after an apartment fire. Unfortunately, some apartments are so severe that the building is no longer inhabitable. In those situations, it may be a good idea to review your lease agreement for acceptable conditions under which you can terminate a lease without penalty. If it mentions you can break the lease if the apartment becomes uninhabitable, you may have a way out of dealing with the long journey of waiting for apartment repairs. If your lease fails to address anything along those lines, you may still be able to break your lease if your apartment is considered a total loss. This designation rarely comes from the landlord but an insurance adjuster. However, if a tenant contradicts the opinion of an adjuster and files a lawsuit, a judge may agree that the apartment is uninhabitable and allow the tenant to break his or her lease agreement. Apartment fire tenant rights under the warranty of habitability don't hold up if the tenant is responsible for causing the fire. So if the building caught fire because you left the burner on your stove overnight or you overloaded your apartment's electrical outlets, you will have a difficult time claiming any benefits or rights that are ordinarily granted to tenants after a fire. Laws in most states specifically state that you cannot stop paying rent and move out if you or your family caused an apartment fire. If you broke your lease and are found to be the person responsible for starting the fire, your landlord could sue you for damages. Take the case in court. If the landlord's negligence is the reason behind the fire, you can pursue the case for damage to your health or goods in small claims court. Apartment fire tenant rights allow you to claim damages in the amount of your security deposit if you left the apartment because it was no longer inhabitable. You have 3 years after the fire takes place to file a case in court. However, if you do decide to file a lawsuit, you will have to prove that the landlord violated his or her responsibilities. It's due to their negligence that your apartment became uninhabitable.